Hi everyone. Today's video will be on the tort of nuisance. We'll be breaking down the tort of nuisance, understand the law, liability, remedies, case laws, and we'll look at some examples also. So let's start. Before understanding the tort of nuisance, let's know what is a tort. Let's see the definition of tort. Tort is a civil wrong that causes harm or loss to another, leading to legal liability. What are the key elements of tort? First one is a duty of care, an obligation to act reasonably and avoid causing foreseeable harm. Second one is that duty of care, a breach has been committed. There is a breach of duty, that is failure to meet the standard of care required. And the result, what has happened? Causation, link between the defendant's action and plaintiff's harm. And because of that breach of duty, a harm has happened. And finally, damages. The finality of the cases of tort results in mostly in damages. There are other remedies also, but the peculiarity of the cases of tort is that it results in damages or compensatory relief awarded to the injured party. These are the essential elements of tort. So what is the purpose of tort law? To provide remedies for individuals harmed by the wrongful acts of other. That is the purpose of tort law, and to deter wrongful conduct and promote social order like most other laws. Coming to what are the legislations governing tort law, there is no statute of a tort law. This is mostly governed by the common law principles developed through court decisions. That is, precedence is the main law, the source of law that is governing tort law. It has evolved over centuries through judicial decisions. Precedents set by landmark cases shape the principles of tort law. So having understood what is tort, let's see what is nuisance, the tort of nuisance. Nuisance is a legal concept that refers to any unreasonable interference with the use or enjoyment of land or property. So it is a wrong committed against the peaceful enjoyment of land or property of another person. It can arise from activities such as noise, pollution, odors, vibration, or other disturbances that disrupt the peaceful enjoyment of property. The key factor in determining nuisance is whether the interference is unreasonable, considering the facts such as the nature of activity, its duration, the extent of the harm caused, and the location of the affected property. See, if your neighbor is dumping the food waste to your property, it comes under the tort of nuisance. Or if he or she is burning some dry leaves near to your compound wall and it is causing you harm, that also comes under nuisance. That is some everyday examples of nuisance. And it is the tort of nuisance aims to balance the rights of individuals, use and enjoyment of property. Now let's see the ingredients of nuisance. First one is significant interference. At the heart of the concept of nuisance lies the requirement of significant interference. This means that the disturbance must be substantial enough to materially impact an individual's ability to enjoy or utilize their property or infringe upon the rights of the public. The degree of interference necessary to establish nuisance varies depending on factors such as the nature of the interference and its effect on those affected. The second ingredient is unreasonable standard. Nuisance also hinges on the notion of unreasonableness. This entails an evaluation of whether the interference exceeds what a reasonable person would consider tolerable under the given circumstances. So the standard is the behavior of a reasonable person. Various factors including location, nature, and duration of the interference are taken into consideration in this assessment. What may be considered reasonable in one setting may not be deemed so in another, highlighting the contextual nature of this element. The third ingredient is intent or negligent considerations. Depending on the jurisdiction and specifics of the case, proving nuisance may necessitate demonstrating either intent or negligence on the part of the defendant. Intentional nuisance arises when the defendant knowingly engages in activities causing interference with the awareness or intent to harm others. Negligent nuisance, on the other hand, occurs when the defendant fails to exercise reasonable care in preventing interference, resulting in the harm to others. The fourth ingredient is duration and continuity assessment. Duration and continuity of the interference are also pertinent factors in establishing nuisance. A persistent or ongoing disturbance is more likely to be classified as nuisance compared to a sporadic or short-term disruption. However, even transient disturbances may qualify as nuisance if they meet the threshold of substantial and unreasonable interference. And finally, plaintiff sensitivity evaluation. Lastly, the sensitivity of plaintiff may be taken into account in nuisance cases. If the plaintiff is unusually sensitive to the interference, it may impact the determination of whether the interference is indeed substantial and unreasonable. However, this sensitivity does not absolve the defendant of liability if the interference meets the established criteria of nuisance. Coming to the next slide, types of nuisance. So there are two types of nuisance. It is private nuisance and public nuisance. Let's see what is private nuisance. Private nuisance is the unreasonable interference with the use or enjoyment of another individual's land or property. We've already seen that the tort of nuisance is the unreasonable interference with the enjoyment of one's land and property. So what distinguishes it from public nuisance? What distinguishes private nuisance from public nuisance is it deals with an individual's land or property. What are the characteristics of it? Typically involves disputes between neighboring landowners. That is the most common case of private nuisance. Interference may include noise, vibrations, odor, pollution, or other disturbances. And it requires proof of substantial and unreasonable interference with the plaintiff's use or enjoyment of their property. Loud parties or music disturbing neighbors are some common examples of private nuisance. Foul odors from nearby factory affecting neighboring residents is also an example of private nuisance. Coming to what is public nuisance refers to an unreasonable interference with a right that is common to general public or a community. We saw in private nuisance it was the right of a person, an individual, but in case of public, a whole mass is affected. It affects health, safety, or comfort of the public at large. It may involve activities that create hazards, nuisance, or obstructions in public spaces, and often involve actions that violate public laws or regulations. Examples include blocking a public road or sidewalk with construction debris, operating a business that emits harmful pollutants into the air or water, allowing a property to become infested with rodents or pests that pose a public health risk. Now we have seen types of nuisances, and next is public nuisance under IPC. In India, public nuisance has been penalized as an offence under IPC or Indian Penal Code. It is defined under section 268 of IPC, and it refers to an act or omission that causes injury, danger, obstruction, or annoyance to the public or to people in general who dwell or occupy property in the vicinity. What are the elements of public nuisance? The act or omission must cause a substantial interference with the public's right. It must affect health, safety, or convenience of the public or a section of the public. And the interference must be unreasonable and unlawful. We have already seen some of the examples of public nuisance, and the punishment for public nuisance is given under section 290 of IPC. Offenders may face imprisonment for a term which makes into 3 months or a fine or both. We'll see what is the difference between public nuisance and private nuisance. Public nuisance affects a general public or a community, while private nuisance affects individual property rights. Public nuisance is prosecuted by the state, while private nuisance is typically litigated between private parties. We have already seen this difference. Now coming to the next slide, defenses to nuisance claims. So if a nuisance claim has come up against you, what are the defenses that you'll be able to argue? The first one is statutory authority. The defendant may argue that their actions causing the alleged nuisance are authorized by law or regulations. Example, a factory emitting noise or odors may argue that it operates within permissible limits set by the governmental regulations. Second one is prescription. Prescription is a defense based on the concept of long-standing use without objection. If the alleged nuisance has existed for a significant period without complaints, the defendant may claim a prescriptive right to continue the activity. If we look at an example, a neighboring property with a long history of loud activities may argue that it has acquired a prescriptive right to make such noise. The third defense that you may take is coming to the nuisance. The defendant may argue that the plaintiff moved to the area knowing about the alleged nuisance. This defense suggests that the plaintiff voluntarily accepted the conditions and cannot now complain about them. A homeowner who buys a property near an industrial zone may not be able to sue the nearby factory for pollution. The fourth one is contributory negligence. If the plaintiff's own actions contribute to the alleged nuisance, the defendant may argue contributory negligence. This defense reduces the defendant's liability proportionally based on the plaintiff's fault. We already know a maxim that a person coming to the law must come with clean hands. If he has contributed towards this situation, he will not have the right to argue against it. An example is if the plaintiff contributes to the noise by hosting loud parties, the defendant may argue that the plaintiff's action worsened the situation. Next is inevitable accident. The defendant may claim that the alleged nuisance resulted from an unavoidable accident or circumstance beyond their control. This defense asserts that the defendant took all reasonable precautions to prevent the nuisance. A sudden and unforeseeable equipment malfunction causing noise may be considered as an inevitable accident. And finally, statute of limitations. The plaintiff must bring a nuisance claim within a specified period after the alleged nuisance occurs. If the claim is not filed within the statute of limitations, the defendant can assert this as a defense. Example, if the statute of limitations for nuisance claims is 3 years and the plaintiff plaintiff files the claim after 4 years of the alleged nuisance began, the defendant can argue that the claim is time barred. Having looked at the defenses of nuisance claims, let's see some important case laws. The renowned case law of Rylance versus Fletcher, which took place in 1868. The facts goes like this. Defendant constructed a reservoir on his land to collect water. The reservoir burst and flooding the plaintiff's mine. The legal principle underlying the decision of the judgment is establish the doctrine of strict liability for activities on one's own land that result in harm to others, regardless of fault. It introduced the concept of strict liability in tort law and expanded the scope of liability for nuisance. The second case is Sturgis versus Bridgman. The facts are, defendant operated a confectionery in his building, causing vibrations that disturbed the plaintiff, who ran a medical practice nearby. The judgment of this case emphasized the importance of locality in determining whether an activity constitutes a nuisance. It highlighted the need to consider the character of the locality when assessing the claims of nuisance. Let's look at the next case, Municipal Corporation of Delhi versus Shubhagwandi. It is an Indian case. The plaintiff filed a suit against the municipal corporation for nuisance caused by sewage overflow damaging her property. The court held that the municipal corporation was liable for the nuisance caused by the overflowing of sewage and awarded compensation to the plaintiff. It established the liability of municipal authorities for nuisance arising from the failure to maintain public infrastructure. The renowned case of MC Mehta versus Union of India in 1987. The facts of the case involved pollution caused by the tanneries in the Ganga River, affecting the health and environment of nearby residents. The legal principle laid down in this case is that pollution constituted a public nuisance and the court directed the closure of polluting industries. The court set a precedent for environment litigation and highlighted the judiciary's role in addressing public nuisance affecting the environment. Finally, coming to the remedies for nuisance. The first one is damages. We've already seen in the first slide when we were speaking about tort that the cases of tort usually end in damages. What are damages? Compensation awarded to the plaintiff for the harm or loss suffered due to the nuisance. Damages aim to restore the plaintiff to the position they were in before the nuisance occurred. Types of damages includes general damages, compensation for pain, suffering, loss of enjoyment, and special damages, compensation for specific financial losses incurred as a result of the nuisance, such as property damage or medical expenses. The next remedy we have is injunctions. The court orders that prohibit the defendant from continuing the activity causing the nuisance are called injunctions. Injunctions aim to prevent future harm and protect the plaintiff's right. Types of injunctions include temporary injunction and permanent injunction. What are temporary injunctions? These are issued during the pendency of the case to provide immediate relief. And permanent injunctions are issued after trial, prohibiting the defendant from continuing the nuisance indefinitely. The third remedy we have is abatement. Physical or legal measures taken to eliminate or reduce the nuisance are called abatement. Abatement may involve removing or altering the source of the nuisance to prevent further harm. Example of abatement measures include repairing or modifying equipment or structures causing noise or pollution, erecting barriers or soundproofing walls to mitigate disturbances. Finally, quieting of title. Legal action to establish or confirm the plaintiff's rights to use or enjoy their property without interference is called quieting of title. Quieting of title lawsuit seeks to resolve disputes over the property rights related to nuisance. The court's judgment affirms the plaintiff's title and may include orders to cease interfering with the plaintiff's property rights. Now we have come to the end of breaking down of nuisance. We have looked at the case laws, the definitions, the different kinds, remedies, defenses, and coming to the conclusion, nuisance law plays a crucial role in protecting individuals' rights to use and enjoy their property without unreasonable interference. Understanding the types of nuisance, elements of liability, and available defenses is essential for navigating nuisance claims effectively. By applying legal principles, remedies, and case precedents, we can address nuisance effectively, promote social order, and protect the rights of individuals and community. Hope you all understood the concept of nuisance. Thank you for your attention and time.